Organic Act of 1871, an act to provide a government for the District of Columbia. In 1871, 3 years after the illegal ratification of the 14th Amendment, the government defaulted on its war debts, forcing America into bankruptcy. 12. What resulted is considered the death blow to the United States for America. 13. On February 21, England claimed what was theirs, according to international law, and incorporated the 10-mile square that is Washington, D.C. 14. England also incorporated the American Constitution and names for its new corporation, such as the United States of America, U.S., and USA, as well as other titles, as declared in the District of Columbia Organic Act of 1871. 15. A point of interest in these copyrighted names is the implementation of the article the. Before this time, America was a union of United States, not a union of the United States. The article the doesn't exist when referring to other countries, i.e. Canada and Britain aren't referred to as the Canada or the Britain. The British-controlled corporation, the United States of America, exclusively uses the article the in its name, which is distinct from the United States or the United States. One other immense change to America simultaneously occurred. Being a bankrupt nation, the United States retained only the power to settle civil disputes, not criminal matters, allowing room for the illusion that only Britain's private, ever-changing laws appertain to America's criminal disputes. British law literally attempted to fill the gap created by the bankruptcy without anyone knowing, making it appear that everything was going just as usual. Since this point in history, the United States of America has been governed entirely by foreign, private, corporate law, and Washington, D.C. has been under British control. The United States of America is a corporation, whose jurisdiction is applicable only in the 10-mile square parcel of land known as the District of Columbia and to whatever properties are legally titled to the United States, by its registration in the corporate county, state, and federal governments that are under military power of the United States and its creditors. 16. Being incorporated, people need permission to use Britain's imposed laws. These people, who use this British legal system for and usually against the American people, are referred to as attorneys, as opposed to lawyers. Yes, there's a difference. The word attorney comes from attorn, which means to turn over to another, transfer. 17. In Old England, the title of attorney meant one who attorned is the Old English, which meant to transfer money, goods, etc. to another. 18. Attorneys served the king or queen in handling disputes regarding money, goods with their peasants. In modern times, attorneys transfer things of monetary value through court procedures to both other forms of money, goods, and to new owners, being either persons or the government. 19. Attorneys have limited legal power because they are sworn to uphold the British, copyrighted law. A lawyer isn't limited like this. Many believe that one needs to get licensed in order to practice law. This is an utter fiction. One needs to become licensed if one wishes to become an attorney in order to avoid a copyright violation. 20. And the way to do this is to pass the bar exam and register with the American Bar Association. The American Bar Association is an appendage of the Bar Council, which is the Bar Association of England. The term bar is an acronym for British Accreditation Register. 21. The registry for those who have been accredited to use America's British copyrighted law. Beyond this point in America's legal history, any laws that came about were private laws of Britain. Any sovereign citizen is exempt from these private laws. Anyone who doesn't dispute being a 14th Amendment citizen is subject to these private laws. The 13th Amendment eliminated involuntary servitude, but it said nothing about voluntary servitude. The 14th Amendment was a gateway for voluntary servitude to take place. At this time, simply claiming to be a sovereign citizen and not a 14th Amendment citizen was, legally speaking, enough to avoid being subject to Britain's private laws. How could the Brits get people to agree to be these citizens? The answers they found were implemented into a plan that materialized into the New Deal.